My name is Jay Hawkinson. I'm a board-certified executive advisor and fractional chief data and AI officer. For the past 25 years, I've been building data and AI functions at industrial manufacturers, global CPG companies, and PE-backed enterprises. I've been in the room where these decisions went very wrong, and in the room when they went right. The difference between the two is almost never the technology. In the next 45 minutes, I'm going to walk you through 5 real AI governance failures, real cases, real courts, real dollars, and one common thread running through all of them that your board needs to understand before the regulators and litigants arrive. Colorado's AI Act, not the version that was supposed to take effect on June 30th, the version that was repealed, Governor Polis signed SB 26189 on May 14th, replacing it with a new framework that takes effect at January 1st of 2027. The EU Act deployer obligations under Article 26 follow on August 2nd of this year. I'm not going to lecture you about compliance, but what I'm going to show you is what happens with organizations that did not have their governance in order when the questions got asked and what those questions really were. No slides, no frameworks, 5 cases, and the conversation they are forcing in every boardroom I walk into right now. Every one of the cases I'm about to walk you through has been reported as an AI failure. A chatbot gave bad information, a hiring algorithm discriminated, a claims algorithm denied coverage, a delivery system broke down. None of them are really technology failures. Every single one is accountability failure, an authority failure, a governance failure. Someone built or deployed a system without establish in writing with named owners who is responsible for the outputs, who can override it, and who is accountable when it's wrong. The gap is what the courts are finding. The gap is what Colorado and the EU are now requiring you to close. And that gap is what I work on with boards and operating executives to fill before the lawsuits come. The question that runs through every one of these cases is the same. When the AI system made the wrong call, who had the authority to stop it? In most organizations, the honest answer is nobody. At least not by name, and certainly not with documented authority. Let me show you what that looks like in practice. 5 cases, starting with the one that surprised people the most when the judge ruled. That first case is Air Canada versus Moffatt. This was about a chatbot liability. Air Canada's website deployed a chatbot to handle customer inquiries. A customer named Jake Moffatt asked the chatbot about bereavement fares following a family's death. The chatbot told him he could book at full fare and apply for a bereavement discount retroactively within 90 days. Unfortunately, that was wrong. Air Canada's actual policy did not allow retroactive discounts. Moffatt booked, paid full fare, and submitted for the discount. Air Canada denied it, citing the correct policy. Moffatt took them to Canada's Civil Resolution Tribunal. Air Canada's defense was simple, that the chatbot was a separate legal entity responsible for its own statements, and that the company should not be held liable for what the chatbot said. The tribunal rejected that defense completely. The ruling? Air Canada is responsible for all the information on its website, including the information provided by the chatbot. The chatbot is not a separate legal entity. The company must honor what the chatbot told the customer. Air Canada's defense was easy and simple, that AI said it, not us. The tribunal's response was essentially, you deployed it, you own it, you said it. That principle, deployer accountability for AI outputs, is now foundational in AI law. Every regulator, court, and enforcement agency in the past 2 years have applied some version of it. The failure here was not a hallucinating chatbot. The failure was that no one had established in writing who is accountable for the chatbot's outputs. There was no named owner for what the chatbot said. There was no override protocol. There was no human review layer for bereavement fare requests. The dollar amount was small, about 800 Canadian dollars. The precedent, enormous. Deployers own the output, full stop. For manufacturers and PE-backed companies in this room, ask yourself this. What does your AI system tell customers, employees, or other parties? Who is accountable for those outputs? If a customer or employee relies on what your AI says and it is wrong, who in your organization owns it? I'll leave you with one governance question. For every AI system that you use in a customer or employee-facing context, who is the named accountable person for what it says? Not the vendor, it's you. The second case is Mobley versus Workday. This is about hiring discrimination. Facts were simple. Derek Mobley, an African-American man with over 40 with disabilities, applied for more than 100 jobs through Workday. He was rejected for all of them, in many cases within minutes of submitting his application. He filed suit alleging that Workday's AI screening tool discriminated against him on the basis of race, age, and disability, in violation of Title VII and the ADA. Workday's defense was that it was a software vendor, not an employer, not an employment agency, and therefore not subject to employment discrimination laws. But the court rejected that argument. It found that Workday could be held liable as an agent because Workday's customers had delegated the traditional function of screening and rejecting candidates to Workday's AI. In May of 2025, Judge Rita Lynn granted preliminary certification as a nationwide collective action. So Workday was ordered to provide its full customer list so that the affected applicants could be notified. The scope? Workday's own filing stated that 1.1 billion applications were rejected using its AI tools during the relevant period. The collective could include hundreds of millions of members. That number should stop every HR leader in the room. 1.1 billion applications rejected by an AI system without individual human review? If even a fraction of those applicants were discriminated against on a protected basis, the exposure is incalculable. The legal development that matters most for your organizations is that the court said that using a vendor's AI tool to make employment decisions does not move the liability to the vendor. You delegated the decision. You own the outcomes. The same principle Air Canada learned, deployers own the output. The governance failure here was a complete absence of human oversight. No one reviewed the AI's recommendation against protected class outcomes. No one was named accountable for the screening function. No one had the authority to halt the screening process when the outcomes looked wrong. For any organization using AI in hiring, scheduling, performance management, or workforce allocation, Colorado's new AI law, SB 26189, it's effective January 1st of 2027, governs automated decision-making and consequential decisions, including employment. The question is not whether or not your AI is discriminating. The question is whether you have the governance structure to know if it is, and the named authority to stop it if it is. The question I'll leave to you guys is this. Who reviews your AI-assisted hiring or workforce decisions against the protected class outcomes? Not the vendor's algorithm, a named human with documented authority. The next case is Lokken versus UnitedHealth. UnitedHealth Group deployed an AI tool called NH Predict, developed by its subsidiary and Navi Health, to make coverage decisions for Medicare Advantage patients requiring post-acute care, rehabilitation, skilled nursing, extended recovery. The algorithm determined how long patients' stay would be covered. When NHA Predict said the stay was complete, coverage stopped. The complaint filed in federal court in Minnesota alleged that the system had a 90% error rate, meaning that 9 out of 10 coverage denials that were appealed were ultimately reversed by federal administrative law judges. The patients who were wrongfully denied care had to either pay out of pocket, deplete family savings, or leave care facilities prematurely. Those who could not afford to appeal, roughly 99.8% of affected patients, received no corrective action. In March 2026, the court ordered UnitedHealth to disclose the NH Predict algorithm. The court found that UnitedHealth could not invoke trade secrecy to shield the algorithm for legal scrutiny. The case remains active. But look at it this way. A 90% error rate, alleged in the complaint, and the basis of which appeals were reversed. Think about what it means in operational terms. If you deployed a manufacturing quality control system that was wrong 9 times out of 10 on appeal, and you continued running it, you'd be in front of OSHA within a week. In this case, an AI system with 90% error rate on appeals continued running for years because only 0.2% of affected patients appealed. That is the governance failure this case names directly. The system was wrong. The organization knew it, and they continued running it because the economics worked, not despite the error rate, but because of it. When only 1 out of 500 patients appeal, a 90% reversal rate is not a problem. It's a profit model. The court's ruling on disclosure is significant. You can't hide your algorithm behind trade secrecy when that algorithm is making consequential decisions about real people. Transparency obligations are coming from every direction. Colorado, the EU Act, the courts. The question is not whether your algorithm will eventually be visible. It is whether you can defend it when it is. For industrial and PE-backed companies, the parallel in AI is in quality, safety, and operations. If your AI system is producing recommendations that your operations team is overriding at a high rate, that is a signal, not a technical one, a governance signal. Someone needs to own the question of whether the system is fit for the decisions it's informing, and that someone needs to be named. Question this one is, what is the override rate on your AI system? Who tracks it? Who owns it? Do you know it? If no one has that number, there's a gap. In May 2026, this is a brand new one, a Pizza Hut franchisee operating in New York filed a $100 million lawsuit against Pizza Hut franchisor. The claim? Pizza Hut mandated that the franchisees use a specific AI-powered delivery operating system. After the system was deployed, delivery performance collapsed. Before AI, more than 90% of deliverables arrived within 30 minutes. After deployment, on-time delivery fell significantly. Sales in New York dropped close to 20 percentage points. The franchisee alleged that despite these documented performance failures, the franchisor continued to mandate the system. There was no mechanism for the franchisee to halt the system, no named donor of system performance outcomes, no override protocol, and no documented escalation path when the system's outputs began destroying business. This case introduced a new dimension that the other 4 did not: mandatory deployment. The franchisee did not choose the AI system, it was mandated. And when it failed, there was no named donor, no halt authority, no way out. The lawsuit is about who is accountable for mandatory AI system failures when the mandate prevented the operator from choosing differently. For anyone in a PE-backed or franchise operating model, this case should land hardest. Portfolio companies and franchisees are increasingly operating AI systems mandated by the parent. the platform, or the PE principle. The governance question is the same. If the system produces wrong output, who has the named authority to halt it? If the answer is the parent decides, then that parent owns the exposure. The authority to stop question is one of the most important ones that organizations have to answer, and they never have. Model selection, training data, accuracy benchmarks, compliance documentations, oh yeah, all that gets the attention. But the simple question of who, by name, could halt a running AI system when the output is wrong? In most organizations, that authority does not exist in any documented form. The case is what happens when it doesn't. Sales dropped nearly 20 points. The system kept running. This is not a technology failure. This is an authority failure. No one had the documented right to pull the plug. So, if your consequential AI systems began producing outputs that were hurting your business today, right now, who has the named authority to halt it? Not pause it for review. Halt it. Is that person's name written down someplace? There's a lot of regulatory deadlines coming up. EU Act, August 2nd. Fannie Mae, August 6th. Colorado, January 1st, 2027. This isn't a court case. This is law. Two of them, one takes effect January 1st, 2027. The other, August 2nd of this year. The Colorado Act, SB 26-189, effective January 1st of 2027. It's the important one for people to understand. There was originally another SB 26-189, but on May 14th, 2026, Governor Polis repealed and replaced it. The new law takes effect January 1st. The framework shifted. The original law required impact analyses, risk management programs, and duty of care. The new law governs automated decision-making technology used in consequential decisions. It requires developer documentation duties, consumer notice and disclosures, a 30-day post-adverse outcome disclosure requirement, and meaningful human review rights. The Colorado Attorney General must adopt implementing these rules by January 1st, 2027. The consequential decisions under SB 26-189 include employment, credit, housing, healthcare, insurance, education, government services, and legal services. The new law uses the term automated decision-making technology rather than high-risk AI systems. If you're in manufacturing and you use AI in hiring, performance evaluations, or workforce scheduling, for Colorado employees, you are in scope. If you extend credit to a Colorado customer through an AI-informed process, you are in scope. Enforcement by the Colorado Attorney General under the Colorado Consumer Protection Act. Violations are treated as deceptive trade practices. No private right of action under the statute. The AG must finalize implementing rules by January 1st. And the joint motion filed in April of 2026 confirmed the AG does not intend to enforce the law until after all the rulemaking concludes. This is not a green light to wait. It's your runway to get your governance documented before enforcement begins. The EU Act, Article 26, which is effective August 2nd of 2026. This is deployer obligations. 5 months before Colorado's January 1st date, the scope under Annex 3 is broader than Colorado. It includes AI systems influencing workforce allocation, scheduling, performance evaluation, and extends to safety-critical systems. Penalties under Article 26, the highest of $15 million or 3% of worldwide annual turnover. For a company at the lower end of ICP, a $200 million in revenue, the 15 million euro flat fee represents 7.5% of global revenue. That is not a rounding error. And Article 5, the EU's prohibition against uncertain AI practices has been enforced since February 2nd of this year. Its enforcement's not theoretical. It's already running. And the August 2nd is the next phase. The common requirement that both laws require that somebody by name be accountable for how AI systems is governed. Both laws require documented oversight. Both laws require a mechanism for human review of outputs. Neither law requires the model to be wrong. They require to prove you are governing it. The next thing to consider is, what does a defensible posture look like? I'm not going to give you a compliance checklist. I'm going to give you 3 basic questions. If you can answer all 3 with specificity and documentation, you are materially better positioned than probably 90% of the organizations. In the 5 cases I walked you through, if you can't answer one of them, that's where your gap is. So question 1, where are you using AI today? And which systems make or influence consequential decisions? You can't have governed what you have not mapped. Every regulator, every court, every buyer in the diligence process asks the question first, not as a compliance exercise, but as a threshold question. If you can't answer it, nothing holds up. Consequential decisions under Colorado and the EU Act include employment, credit, healthcare, housing, and education. But the operating definition is broader for governance purposes. Any AI system whose output materially influences a decision that affects a customer, employee, or other party, that includes your demand forecasting if it drives inventory decisions that affect customer service. That includes your predictive maintenance if it influences safety-critical operations. The output of this question is an AI inventory, not a technical inventory, a decision inventory. Which decisions, what decisions, which systems, what outcomes? Question 2. Who is the named accountable party for each significant AI system? Named, not a team, not a department, a person with their name, title, and documented accountability in writing. This is a gap in every one of the 5 cases I just walked through. No named owners, diffused accountability, which means, in essence, no accountability. The accountability map covers 4 roles for each system: who owns the model, who owns the decision the model informs, who is authorized to override the model output, and who's authorized to halt the system. These 4 roles can be the same person. They can be 4 different people. What they can't be is unnamed. The VTCDO governance framework builds this accountability map as its first deliverable. I'm not selling you anything in this session, but if you want to see what the output looks like, there's a manufacturing scenario sample. I'll put it in the chat in a little bit. Question 3. Who has the authority to halt the system, and does that person know they have it? This is a question that's missing from every governance framework I have seen in the wild. Model governance, data governance, risk governance, all of them address what happened and how to report it. None of them address who can stop the system when the output's wrong in real time. Pizza Hut franchisee could not halt the system. UnitedHealth kept using their system, alleging a 90% error rate. Air Canada's chatbot kept telling customers they could get a retroactive discount. Workday's algorithm kept rejecting applicants within minutes. In none of these cases was a named person with documented authority to halt the system. In all the cases, the organization paid. The authority to stop is not a technical configuration. It is an organizational decision. Someone has to be named. That name has to be written down. That person needs to know they have that authority, and there has to be a protocol for when and how they exercise it. So do you know where you are using AI and which systems make consequential decisions? Is there a named person accountable for each significant system with documented authority to override and halt? And does that person know they have that authority, and has it been tested? If you can't answer all 3, there's a gap, and the regulators and litigants are finding it. Now, if you'd like to go add some questions and answers, put in the chat. I'll answer anything that I can, and we'll go from there. But I do want to bring up one other topic for you guys today, and that's shadow AI. One more governance dimension that lands naturally is what happens with AI systems that we are not aware of. All of us have them. People in our business is going out there doing things in AI, and it's not on IT's list. It's not on the executive's list. We have absolutely no clue. But the reality is, and the question is, does a company have responsibility for AI decisions even when an employee is using AI in the background, unofficially? The short answer is yes. And the 5 cases we just walked through already prove it. The Workday case makes it clearest. Workday argued it was just a vendor. The employer had the employment relationship, not Workday. The court rejected it. The deployer owns the output. Now flip that logic inside your own organization. If an employee is using an AI tool, ChatGPT, Copilot, anything else, and it's not officially sanctioned to screen resumes, draft performance reviews, generate pricing recommendations, or inform a consequential decision of any sort, and the organization acts on the output, that organization owns the outcome. The fact that the tool was unauthorized does not transfer liability. It may make the exposure worse because it proves the absence of governance. Shadow AI creates 3 compounding problems. First, you cannot map what you cannot see. The EU Act and Colorado both require a documented inventory of AI systems influencing decisions. If an employee is running tools outside official channels, those systems are not in inventory. You're already non-compliant. Secondly, there is no named accountability. The entire framework of the 5 cases establishes that someone must be named responsible for each of the system's outputs. With shadow AI, nobody is named because no one officially knows the system exists. Third, there is no halt authority. You can't halt a system you do not even know is running. Lender Letter 2026-04 requires mortgage sellers and servicers to disclose AI tools in use on request and hold vendors and subcontractors to equivalent standards. That language is written to capture exactly the scenario: an employee using an unofficial AI tool to support a regulated decision. The practical framing? The question is not whether or not your employees are using AI and you've not approved it. They are. Take that for granted. The question is whether or not the consequential decisions, the kind that affects customers, employees, other parties, are affected by regulating outcomes, are being influenced by AI. Systems that have no named donors, no oversight layer, no halt authority. That is the exposure, not the tool itself. It's the accountability gap around it. So lastly, here's the question you should ask yourself. Can you tell me today which AI tools your employees are using to inform decisions? Not the tools IT has approved, the tools they're actually using. If you can't answer that question, your AI inventory is incomplete and your governance posture has a gap that regulators will find before you do. So I gave you 5 cases. One common thread: organization that ended up in court, front of regulators, in deposition, are not organizations that built bad AI systems. They are organizations that built or deployed capable systems without establishing who owned the decisions those systems produced. The EU AI Act deployer obligations take effect on August 2nd. Colorado's new AI law, January 1st. The question the law is now requiring you to answer is by name, in writing, with documentation, is the same question that runs through every case. Who is accountable? Who can halt it? What happens when it's wrong? If you are a board of director, a CIO or CDO, or a PE operating partner, and you walked away from this session knowing that questions does not have a documented answer at your organization, that is the starting point. Not a compliance project, a governance conversation, one that needs to happen before the regulators come and visit you. The VTCDO AI Governance Readiness Assessment builds that accountability map. It produces a gap analysis, a risk register, and a 90-day action list. There's a free sample output at vtcdo.com/sample-AI-readiness. It's built on a manufacturing scenario, and it shows you what accountability map, posture score, and the regulatory exposure sections look like before you commit to anything. So thank you for your time today. I'm in the chat, and if you have any questions about a specific case, a specific regulation, or where your organization stands, I'll help answer it here. If you want to continue the conversation offline, send me a message on LinkedIn, Jay Hawkinson 00. This is the first of a series of sessions we're running through the summer and into the fall. Each one is built around a specific governance failure or a regulatory deadline that is live right now. The next session is on July 7th. The topic is why most boards have already approved the AI risks they think they are still evaluating. The registration link will be in the comments. If you want to know when that next one drops or the new ones that we're going to have coming up, follow me on LinkedIn or subscribe to the Decision Register newsletter. Lastly, I want to thank you all again for coming and visiting. And if you comment brief below, I will send you the complete session notes, the 5 use cases for that brief that I have directly. You should also have them in your inbox if you went to VTCDO/5-cases-brief, but comment brief and I'll make sure it gets to you. Again, this is episode 1. Comment the keyword and I will get the stuff within a couple of hours to you. So the DM link again is VTCDO/5-cases-brief. Thank you very much and have a great day.